MSW Media.
So yeah, now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Welcome to episode 206 of Clean Up on Aisle 45. It's Wednesday, January 1st, 2025. Happy New Year. I'm Allison Gill.
And I'm Harry Dunn. We have a lot to cover today, including another win by writer E. Jean Carroll, another win for her, another loss for Donald Trump, as the Second Circuit Court upholds her first defamation and sexual assault ruling against Donald Trump.
She's such a badass.
She is. She really is.
Her and her lawyer, Robbie Kaplan, are just supremely awesome. And I'm so happy that Second Circuit ruled this. And the rest of the show will be about Rudy.
This is great.
It's like we're cranking, like on the roller coaster, cranking up to the tippy top with all of these different things converging on his stupid face at once. He's about to have sanctions imposed against him by Judge Liman this Friday. This is January 3rd, and we'll go over what the sanctions will probably be. They're going to come in the form of adverse inferences and preclusions, which are very, very bad news for him. And it could be other stuff. He could be fined. He could be put in jail. I don't know. But we'll see. And we're also going to talk about the fact that his response to Judge Howell is due tomorrow.
Yeah.
For why he shouldn't be held in contempt in her court for continuing to defame Freeman and Moss. Remember how he was on his podcast saying they plotted to assassinate Donald Trump and all this bullshit.
It's so funny. It's due tomorrow. What are the odds that it actually gets filed?
Well, his new lawyer, Joseph Camerata, seems to want to turn stuff in on time because on Christmas Eve, Camerata filed a couple of things along with Rudy, begging the court, this is Liman now, not to hold him in contempt for failing to hand over his stuff, right, to the receivership. Yeah. He's got a really interesting argument. We'll talk about that. But first, we have our new December patrons to thank, including Val R.A., Sydney, Whitney Darwin, Elizabeth Cusalito, the original Chris Smith. Okay, the original.
The original.
Mm-hmm. And Connie Moore. Thank you so very much for supporting independent media. We couldn't do this without you. And we do have a really nice quick correction from our last show, from Ciara, I believe. And if I'm pronouncing that incorrectly, send us another correction. They write, you confused Judge Dale Ho in the Southern District of New York, appointed by Biden, with James Ho, Fifth Circuit, appointed by Trump. Judge Dale Ho has the Mayor Adams case. Thanks, Ciao, Ciara, law professor and Brennan Center fellow. So I am going to take whatever Professor Ciara says on its face.
We have some really smart listeners here. We have some very smart listeners.
I'm like, man, I told dick jokes for 10 years and y'all want to listen to me talk about the law. I love it. You can find and follow Ciara, by the way, at Prof. Ciara, Ciara, on Blue Sky. I encourage everybody to join Blue Sky. It's so nice there.
So nice there. It is.
It really is. All right. Thank you all so much. Thanks to our patrons and thanks to Ciara, the professor. Okay, Harry, where do we want to start today?
Well, how about let's start with the Second Circuit upholding the $5 million judgment against Trump in the E. Jean Carroll case. Perry Stein at the Washington Post writes, a federal appeals court Monday upheld a $5 million New York civil trial jury verdict that found Donald Trump liable for sexually abusing and defaming writer E. Jean Carroll. The ruling by a 3-judge panel of the U.S. Court of Appeals for the Second Court in Manhattan said that Trump did not demonstrate that the district court erred in any of the challenged rulings.
Yeah, so this is good news. This is a per curiam order. No names are signed to it. And I have to wonder if they did it that way so that Trump wouldn't know which judges did this.
It's funny, but it's kind of true, though. Like, that's his MO, going after people. I wonder, you might be right.
It is. So 3 judges ruled this. This is a regular Second Circuit panel of judges. And, you know, the way that the appeals process goes is you get it up to the appeals court from the lower court. 3 judges hear it, 3 judges rule. And then Trump has indicated he wants to appeal this ruling. But he hasn't said whether he's going to appeal to the en banc Second Circuit, which is all of the judges on the Second Circuit, or if he wants to take this up to the Supreme Court directly. The article goes on to say that in May of 2023, jurors determined that Carroll had sufficiently proved she was sexually abused in a dressing room at the Bergdorf Goodman department store in Manhattan in the mid-90s after a chance encounter with Donald Trump. The jury also found that Trump defamed Carroll years later on social media after she publicly accused him of rape. The jury awarded Carroll a total of $5 million in this particular case, and this case is known as E. Jean Carroll 2. The first case went to trial after this case, E. Jean Carroll 1, and that is the one that awarded $83.3 million. But this is E. Jean Carroll 2, but it went first. She got $5 million. Yeah. Trump appealed, arguing that Judge Kaplan admitted evidence at trial that he should not have, including, quote, an Access Hollywood recording, because we haven't all heard that shit.
Right?
Like,
that is insane.
Should have been evidence.
Exact. Oh my gosh.
That recording was first reported by the Post in 2016, in which, Trump talks in graphic terms about grabbing women by their genitals. Trump's team also argued that the judge wrongly allowed the jury to hear testimony from two women who alleged Trump had sexually assaulted them as well.
The federal panel ruled Monday that the judge's decision to allow the jury to hear that evidence was proper and that the district court did not abuse its discretion in making any of the challenged evidentiary rulings. The judges wrote, the jury made its assessment of the facts and claims on a properly developed record.
Nice.
In response to the appeals court ruling, Trump spokesperson Stephen Chung said in a statement that the decision would be appealed and that the case should be dismissed. Voters who elected Trump in November to a second presidential term demand an immediate end to the political weaponization of our justice system.
What are you about to do, bro?
What?
Yeah. Roberta Kaplan, Carroll's attorney, said in a statement, both E. Jean Carroll and I are gratified by today's decision. D. John Sauer argued on behalf of Trump before the appeals court in September. Trump had said he would nominate Sauer to serve as his Solicitor General. This is the same guy who argued in front of the Supreme Court that Trump should be able to order SEAL Team 6 to assassinate
the
his
immunity
political
case.
Mm-hmm. Yeah. The Solicitor General is the government's top advocate before the Supreme Court and the fourth highest ranking Justice Department job. Trump's legal team could ask the Second Circuit to rehear the appeal, like I said, en banc, with every judge on the court hearing his appeal for a second time. His defense attorneys could also appeal directly to the U.S. Supreme Court. And again, they haven't indicated which route they're going to go. Trump usually likes to go the route of filing en banc with the full circuit before he goes to the Supreme Court because he likes delay. But I don't know if he likes delay so much anymore because he's trying to be president.
Absolutely. But talking about the Supreme Court, you know how much they love him. But anyway, Trump's public disdain for Carroll started soon after she first publicly alleged in a 2019 magazine excerpt from her memoir that he had sexually assaulted her decades earlier. Trump, who was president at the time, called her a liar, claimed she was a complete stranger to him, and suggested he could not have assaulted her because he found her unattractive.
Do you remember, too, like in court, Robbie Kaplan, E. Jean's lawyer, showed Donald Trump a picture and was like, who's that? It was there?
Marla, wasn't it?
He said it was Marla, but it was E. Jean Carroll.
It was E. Jean Carroll. Marla Maples. Unbelievable. Separately, New York jurors in a different civil case concluded that Trump defamed Carroll and owed her more than $83 million. The first guilty verdict found that Trump was liable for sexually abusing Carroll and defaming her in a social media post in 2022. The second $83 million judgment found that Trump acted with malice as he defamed her for years.
Yeah. And going into that second trial, which is actually E. Jean Carroll 1, the $83 million trial, the judge was like, you all can assume that he did this. You just have to determine how badly he did it and what it's worth. And so this really kind of cool expert came in and said, the $5 million judgment for this one social media post and for the sexual abuse is, based on the reach of that one post. But for the $83 million one, the expert came in and said there was this post and this speech and that speech, and here's how many people it reached, and here's how it destroyed E. Jean Carroll's reputation and the massive impact of it. And that's why, because the reach was so much broader in that second trial.
Yeah.
That it was an $83 million award. Plus, they were like, you got to award an amount that will deter him from continuing to defame E. Jean Carroll, something that Rudy Giuliani hasn't learned, apparently.
My goodness, he's never going to learn.
No, I don't think he is. But I'm really, really happy for E. Jean and Robbie Kaplan here. She didn't give up like ABC did.
That's where I'm glad that you said that, because that's where my thought immediately went. When I heard the news about this, I thought of two things. Well, one, about Chung's statements about appealing this going forward. And he brought up the voters in the election, they moving forward. That's not what civil suits are about, my friend. It has nothing to do, which way, on a separate note, we'll talk about this as in the coming year. The civil suits against Donald Trump regarding January 6th, that's still hanging in the balance there. So we'll get to that in a couple weeks coming up. But that has nothing to do with what you can say out your mouth, and you can't defame people. So it has nothing to do with voters say. That does not matter. But also, like you just acknowledged about ABC, why I'm still so anxious to know, why did they settle? They were right. They were not wrong. And it's kind of like obeying in advance. And it's just like being on his good side. And it's really unfortunate that E. Jean Carroll and Kaplan are showing more fortitude. I'll say that, more fortitude than ABC executives and their board of directors or whoever is responsible for making that decision. But I'm glad that they are standing up and continuing to hold Donald Trump accountable.
Yeah, I'm with you. ABC would have won that case. And not only did they cry uncle, they gave Trump $15 million for his future presidential library.
Unbelievable.
I'd be surprised that you would need any money to buy books for that. It'd be great if you just somebody bought like all the banned books and sent them to
put it into the library. That'd be awesome. Epic troll right there.
It's all E. Jean Carroll's books.
Oh, yes.
Just copy after copy.
I am here for that level of trolling. Let's do that.
No, me too. That's why I think Ruby Freeman and Shaye Moss should throw a big New Year's Eve bash. Because we record this on New Year's Eve, but it comes out New Year's Day in the New York apartment that now belongs to them. I'm a low road Democrat these days. I really am, and that kind of petty is I'm all for it. But
here for it.
But they're doing their best. They're staying professional, and we're going to talk about all of these Rudy contempt motions coming to a head in the next few weeks. The January is going to be a very, very bad, no good month for Rudy Giuliani. And we'll go into detail right after this quick break. Stick around. We'll be right back.
Welcome back. All right. We usually end the show with Rudy Giuliani. And today is no different. There's just so much going on with him that we have to start it in the B block. Like, we want to end with Rudy. We're going to end with Rudy, but we have a lot of Rudy to cover. So Rudy has 3 pending motions for contempt filed by Georgia election workers Ruby Freeman and Shaye Moss. The first is with Judge Howell in D.C. because Rudy continues to defame Freeman and Moss after Judge Howell ordered him to stop. Rudy's response was initially due December 2nd, but he wrote a letter to the court saying he was unable to find new lawyers. Remember, blaming the judge. Mm-hmm. Remember he said that?
Yeah.
It's your fault, Judge. It's your fault.
I talked to 4 lawyers and they all hate your face.
He said no one will take the case because Judge Howell is so biased and hates Rudy so much that he can't win. Judge Howell gave him some more time, and now his response is due tomorrow. We don't have that filing yet, but we'll go over it next week. Judge Howell has set a hearing for the contempt for Rudy on January 10th, which is right around the corner. And Judge Howell warned him that any more requests for the delay would be viewed with continuing skepticism.
Yeah, which is judge speak for shut the fuck up. And you remember when Rudy filed his thing, like his motion for more time, he forgot to sign it. And she's like, denied without prejudice. Try again. I can't believe you were a lawyer forever.
You didn't even sign your permission slip, buddy.
So he finally filed it again, got it turned in, and she's like, all right, I'll give you till tomorrow. So he has until tomorrow to file this. And you're right. I'm interested to see if he even hands anything in, but he's got Joe Camerata now on his team. So we'll see.
So let's see how that goes.
Yeah, right. The second contempt motion is because Rudy hasn't handed over a single page of discovery and has failed to respond to interrogatories for the upcoming trial over whether his Florida condo is his primary residence. So interrogatories are like you ask the other side a bunch of questions, like confirm that or admit that you did this, admit that this is your vacation home, give us your phone number, tell us where you've been living, give us your tax returns. These are interrogatories, and he's not handing anything over in this case. And we'll talk about that. We'll also, the third contempt motion is because he's not handing over his assets to receivership. And we'll talk about that later in the show. But for now, let's focus on the Florida condo discovery problems, because that trial happens this month as well. And because Rudy has failed to comply with his discovery obligations, Freeman and Moss have filed a contempt motion, and they've asked the judge to enter something called adverse inferences and preclusions.
That's an interesting term.
Yep. So let's start with some background on why there's a separate trial, first of all, for the Florida condo. Then we'll talk about adverse inferences and preclusions, the ones that Freeman and Moss want the judge to enter into the record. So here's a great explainer I found from CNN this past October, because I'm like, we went over that ridiculous Rudy filing the other week, and it was all like, it's his primary residence. We can prove it's his primary residence. He's been primarily living there ever since 2023 in July when he listed his New York condo. He's been living in the Florida condo. It's his primary homestead, the Florida Constitution says. But they never said why that matters. And I think that that's sort of important to go over. So I pulled this up from CNN. The fate of Rudy Giuliani's $3.5 million Palm Beach, Florida condo, which he says is his primary residence, is now in the hands of a federal judge in Manhattan. The former New York mayor and prominent Donald Trump political advocate plans to stay in the Palm Beach condo now, but will be blocked from doing anything that could diminish its value while the judge sorts out whether his creditors can seize it. That's Judge Liman said that in a hearing back in October.
Yeah, Giuliani's attorney, Kenneth Caruso, wouldn't say in
he's
court.
He's quit, by the way. Caruso has quit.
Caruso has jumped off the sinking ship. Life raft around him, But he wouldn't say in court when Giuliani made the Palm Beach condo his primary residence instead of New York. He didn't say when. Where he lived primarily is a major issue that the judge could decide in the coming weeks. And if the court says Giuliani didn't properly make his home before late this summer, he stands to lose the condo. Better have him answer the question now. It's an answer he presumably knows if what he says is true, Nathan told the judge Monday. Pushing for a quick answer on the date, Giuliani says he moved to Florida. Nathan says his team believes the Palm Beach condo is primarily a vacation home, and Giuliani spent less than half the summer there, instead living mostly in New Hampshire with trips to New York, the Republican National Convention, and the Summer Olympics in Paris.
Remember when he fell down at the RNC?
That was great. I don't wish people to get hurt, but that was I know what you mean. You know what I mean? You know what I mean. But our listeners do too. Y'all know. But after the hearing ended, Caruso told CNN's Giuliani's first step in the process of relocating came in July 2023 when he put his Manhattan apartment on the market with Sotheby's.
So, according to CNN, he has a better chance of hanging on to this condo if he can prove it's been his primary residence. He's saying that it is. His lawyer's like, every Florida court would agree, you're full of it, but he gives no reason, no evidence. The only evidence he mentions is that Rudy's registered to vote in Florida and that he has filed for homesteading on his tax returns, but he won't hand over his tax returns. So he's not handing over any evidence. The article goes on to say, 4 New York Yankees World Series rings are also part of this legal battle, where Freeman and Moss want their debt paid. Giuliani's son, Andrew, told the court his dad gave him the rings at his dad's 74th birthday party in 2018. I call bullshit. But in court, Freeman and Moss attorneys told the judge they've been trying for months, unsuccessfully, to get access to Giuliani's tax returns, which should have declared the gift of the rings worth tens of thousands of dollars each. And so here's what happened. Either Andrew and Rudy are lying about Rudy giving these to him as a gift, or he did give them to him as a gift and didn't put it on his tax returns. Either way, he's in deep shit.
I'm about to say both of those are so on par for Rudy.
Right? So either they're lying to the court.
About it, they're lying to the court, or lying to the tax people, right?
Or lying to the IRS. And so, I'm surprised we haven't seen a pleading of the fifth. I have to plead the fifth to turn over my tax documents, which you can't really do in a
suit. He's not that smart though.
I wouldn't. Disbarred in two jurisdictions. Giuliani did not attend that court hearing. Remember, he missed it. His attorney told CNN he couldn't say if the former mayor was still in New York a day after speaking at Trump's rally in Madison Square Garden. So his lawyer, Caruso, wouldn't tell the court
where
this
he was.
Is his primary residence. He's living in Florida. He's not in New York, or he is in New York, because he knows that if he lies to the court, he's subject to Rule 11 sanctions.
Mm-hmm.
Right? Lawyers get in trouble for that shit.
Yeah.
At that rally, Madison Square Garden, Giuliani hinted at conspiracy theories around Trump's attempted assassination, but he didn't address his issues in court or the belief he had repeated many times before that the 2020 election was stolen. Quote, "I'm not going to do conspiracy, and I'm not going to do conspiracy." That's what he said. But it's kind of funny, he said, that they tried everything else, and now they're trying to kill him. They better not try again, Rudy said. So, wow. Okay.
Yeah. So Rudy is trying to prove that Florida is his primary residence in a bid to hold on to the Palm Beach condo. But as we have discussed, Rudy has failed to hand over a single page of discovery over the matter. And his new lawyer basically lied to the court last week when he said the reason Rudy hasn't handed over anything is because his previous lawyers were never served, which we now know to be untrue. His previous lawyers quit because Rudy was not complying with discovery.
Yep, there was a letter unsealed by the judge saying everybody needs to know this. First of all, Rudy's lawyers quit because there's some software that helps you with discovery, because discovery it's a lot, right? You got to find every single email where you talk about your condo or where you live or whatever. And so there's firms out there who exist solely to help you find discovery, but you have to give them your computer and your laptop and your iPad and your phone. They image them. They do word searches, keyword searches for relevant material. Give that to your lawyer. You guys go over it, decide what's responsive, and hand over the discovery. Rudy refused to give his lawyers his electronic devices to have this firm search for discovery. That's why they quit. They're like, we're out. Plus, he didn't want to stand up in court and lie about where Rudy lives. So, that's not in the article. I'm just assuming.
Yeah, of course.
But it seems pretty obvious. Now, let's explain those, because now we know why he wants to say that this is his permanent residence. He has a better chance of not having to hand over this condo to Ruby Freeman and Shaye Moss. So let's talk about the adverse inferences and preclusions that Ruby Freeman and Shaye Moss are asking for. And as a side note, you recall back in 2023, before this went to trial, before the trial that awarded Freeman and Moss $148 million, Rudy was not complying with discovery then either. And because of that, Freeman and Moss filed a contempt motion for adverse inferences and preclusions. Now, adverse inferences are like little mini rulings before a trial, things that the judge will tell the jury they can assume. Like in a sort of like in the Fox case, you remember there was a partial motion for summary judgment that Fox lied.
Yeah.
And so they went into trial, or they were going to go into trial before Fox settled for almost $1 billion.
Mm-hmm.
And they went into trial. They would have been able to assume that Fox lied, right?
Yeah.
You wouldn't
Also,
have to.
isn't it similar to what we just talked about with E. Jean Carroll? How you can assume Donald Trump committed these sexually abused E. Jean Carroll, sexually or raped her, whatever. You could.
Yeah.
Is that the same thing?
Yeah, because like that second trial that went for $83 million, a jury had already determined.
Yeah.
That Trump defamed E. Jean Carroll and sexually abused her. So they were like, all right, in this trial, we're assuming all that to be true. We don't have to find that fact here.
Yeah. Okay.
All we have to do is determine how bad it was and what it's worth.
Got it.
So in Rudy's case, Judge Howell ruled that because Rudy wasn't complying with discovery, the jury would be instructed that Rudy was intentionally hiding his assets, that he made a lot of money off of defaming Freeman and Moss, that he wouldn't, and some of the preclusions were that he wouldn't be able to introduce any evidence that he himself didn't produce in discovery, and that he wasn't allowed to argue that he's too poor. He can't be like, I'm poor, help me, I'm poor. And he wouldn't be able to try to convince the jury to give him a lower, give Ruby Freeman and Shaye Moss a lower award because poor Rudy is too poor. So those adverse inferences led to the jury awarding the election workers $148 million. So that's kind of what an adverse inference and a preclusion is. Like, preclusions forbid you from introducing evidence or making arguments like I'm too poor. And adverse inferences are where the judge can instruct the jury. Rudy didn't comply with discovery. He's obviously hiding his assets. You can assume that when you're deciding how much the award's going to be. You can assume, like in the E. Jean Carroll case, that he sexually abused her and defamed her because a previous jury decided that. You can assume these things like jury instructions.
Yeah. And for this Florida case, Freeman and Moss wants Judge Liman to enter the following inferences. Further, because defendant has not shown cause why he should not be held in contempt for his refusal to provide complete answers to the subject interrogatories, the court should hold defendant in contempt. And at the January 3rd, 2024 hearing, consider and enter the following adversary inferences. That the identities and correspondingly locations of the defendant's professional services providers would show that Mr. Giuliani did not treat the Palm Beach condo as his permanent residence, as a matter of subjective intent and actual occupancy. You didn't live there.
No, yep. And the jury can assume because you haven't handed over anything that says otherwise. And I think when they may say professional services providers, that's like gardeners, maybe.
Yeah.
Housekeepers and stuff, like your condo
maintenance
fees.
People.
Yeah. Like he was only spending $8,000 a month to run that condo when he normally spends like $15,000 to $20,000 a month when he's actually there. You know what I mean?
Yeah. So that they might be onto something good there.
Electricity, maybe. Shit like that.
Yeah. 2, that the identities and correspondingly locations of the defendant's professional service providers would show that Mr. Giuliani treated the Palm Beach condo as a vacation home, beach house. 3, that the defendant's true answer to interrogatory number 8 would show that the defendant's discovery responses and disclosures were incomplete. And 4, that the defendant's true answer to interrogatory number 8 would show that Mr. Giuliani's unproduced and undisclosed discovery would have been relevant to the questions of Mr. Giuliani's homestead.
Yeah. So that would mean that the court would assume Rudy's condo was a vacation home and not his permanent residence, which basically means he has to hand it over to Freeman and Moss, or it would not help his case to keep the condo. So all of that to say, we have more information on this second contempt motion.
Yep.
Because we got a response from the judge, because Ruby Freeman and Shaye Moss asked for those inferences and preclusions. Another preclusion is that he can't introduce any evidence that he actually lives there. Like, he's totally screwed if these sanctions are applied in trying to keep this condo. But aside from that, we've got a response now from the judge, which basically says, I'm holding you. You're in trouble on January 3rd. Get ready.
Get ready. Ooh, I can't wait.
We're going to go over that ruling, but we have to take another quick break. So stick around. We'll be right back. Hey, everybody. Welcome back. All right. So we are still talking about the second contempt motion. We haven't even gotten to the third one yet. This is the second one for Rudy failing to hand over discovery in his Palm Beach condo trial, and that Freeman and Moss want the court to assume the condo is a vacation home because Rudy won't comply with discovery and he won't answer a couple of interrogatories. Rudy's lawyer then filed a motion for a protective order over the responses to some of these interrogatories 4 and 8 specifically. And this is basically an attempt to delay having to hand over the information. He just doesn't want to hand it over. So remember how he said he didn't think he should have to hand over his phone number and address because he said Freeman and Moss would release it to the public?
Yeah.
That's this, okay?
Yeah.
So here's how the judge responded. Defendant Rudy Giuliani moves, pursuant to Federal Rule of Civil Procedure 26C, for a protective order relieving him of the obligation to respond to interrogatories number 4 and number 8 of the first set of interrogatories of Ruby Freeman and Shaye Moss. The motion is denied. The court addressed interrogatory 4 and interrogatory 8 by memo and order on December 17th, 2024, in response to Ruby Freeman and Shaye Moss's motion to compel. The court granted the motion to compel. The court recited that the interrogatories were first served way back on November 6th, 2024, with an initial deadline of November 20th, 24, and an extended deadline. They gave him another 6 days till November 26, 2024, and the defendant still failed to respond to either of those dates. So we asked these questions back in November.
Mm-hmm.
You were supposed to answer them by November 20th. We gave you another 6 days. You still haven't answered them, and now you're filing a motion to grant a protective order over your answers that you still haven't given.
How about you answer the questions first, then we'll decide if we're going to protect them. Like, he hasn't even... This guy is a cornball. The judge continues. The court held that the defendant's objections to the interrogatories were accordingly waived. The law imposes consequences on parties who disregard their obligations. I'll read that again. The law imposes consequences on parties who disregard their obligations. Seems pretty straightforward to me.
Mm-hmm.
Defendant failed to show any good cause for his tardy responses, and in any event, his objections were without merit.
So you're late and you're dumb.
Simple. I like that. You're late and you're dumb.
Yeah. If we were in, like, if I got my law degree at Costco and we were in Idiocracy, that's how I would be responding as a judge. You're late.
Absolutely.
and even if you weren't late, you're dumb. You know.
Absolutely. The information requested by interrogatory number 4 was squarely relevant to the defendant's claim for a homestead exemption. Plaintiffs had more than met their burden to require defendant to answer interrogatory number 8 because defendant's repeated noncompliance with his discovery obligations had given substantial reason to doubt the completeness of his disclosures to date in this case. The court ordered that the defendant answer the interrogatories by December 20th, 2024, or show cause why he should not be held in contempt for violation of the court's order.
Yep. So he's refusing. The court says, all right, December 20th. And if you don't this time, you got to tell me why I shouldn't hold you in contempt. The judge goes on, though styled as a motion for a protective order, the defendant's motion is in substance a request for reconsideration of the court's December 17th, 2024 order. Quote, a motion for reconsideration should be granted only if the movement identifies an intervening change of controlling law, the availability of new evidence, or the need to correct a clear error or prevent manifest injustice. So basically, instead of responding to the interrogatories or giving a reason why he shouldn't be held in contempt, Rudy filed that motion for a protective order. And the judge is saying it's really a motion for reconsideration, disguised as a motion for a protective order, meaning, Rudy, you just didn't like my decision.
Mm-hmm.
You should have filed a motion for reconsideration, but you didn't. You filed this, and it's denied. Defendant's letter motion does not present any arguments he did not have the ability to present in his opposition to plaintiff's motion to compel. Defendant was obliged to respond to the motion to compel by December 17th at 5 p.m. In his belated response to that motion, the defendant simply said, please be advised that interrogatories 4 and 8 have been transmitted to opposing counsel. Therefore, the letter motion regarding the interrogatories is moot. But the defendant did not offer any defense of his prior objections to the interrogatories. So he said late, okay, I sent it over. So we can just drop this whole thing, right?
No, buddy, that's not how it works, my
friend.
But the judge goes on to say, in his new motion, defendant no longer argues that he complied with the interrogatories. He argues instead that interrogatory number 4 calls for irrelevant information and is overbroad, and that interrogatory number 8 calls for irrelevant information and is designed to embarrass or harass. Rudy, you kind of do that on your own, my friend.
Yeah, really.
The court previously addressed why both interrogatories call for highly relevant information. Defendant does not identify any information the court overlooked.
All right, so let me get this straight. He said on December 17th, we sent over the answers, so you can drop your contempt stuff. But now he's saying, we don't want to send over the answers. So they haven't.
They haven't
transmitted the answers.
Even though he said that he did.
Or he did and he wants a protective order over them. It's not clear. But what else does the judge say?
I like that they call it kangaroo court, but it's kangaroo and Rudy's the kangaroo. But anyway,
yeah.
The judge goes on to say, if defendant is concerned about disclosure of his cell phone number, then the answer would have been for him to request an order under Rule 26C that information be kept confidential from the public. There is no basis to keep it confidential from the plaintiffs or their attorneys. Seems fair. That seems fair.
Well, it makes sense. Send it over to the plaintiffs. But he was like, they're going to release it to the public because they hate Rudy. It's kind of his deal. So has he sent it over or has he not? It sounds like he hasn't.
Has not. It sounds like he has not. The court's order of December 17th, 2024 required defendant to answer the interrogatories by December 20th, 2024, or show cause why he should not be held in contempt with contempt sanctions imposed. Defendant asks that his motion for a protective order serve as his response to the order to show cause. The record is now closed on the order to show cause why the defendant should not be held in contempt.
Oh, shit. So, okay. So this is where Rudy sort of shot himself in the foot, right? Because he had to say why not to hold him in contempt. Instead, he filed this motion for a protective order against these answers for these interrogatories. And so he said, that's my order to show cause. That's my explanation as to why you shouldn't hold me in contempt. And he's like, all right, cool. Case closed. You don't get to say anything else about why I shouldn't hold you in contempt then. That was your answer? Done. Case closed. There's no more opportunity for you, Rudy, or your lawyer to tell me why I shouldn't hold you in contempt because you're telling me this motion for a protective order is it. All right? Done. Denied. And you can't submit anything else to me. So the record is closed. The judge then adds, the court will be prepared to announce its decision on the contempt request as early as the hearing on January 3rd, 2025. The party
Friday.
I'm going to tell you from the bench. The parties should be prepared to address the question of why, if the defendant is held in contempt, why the court should not impose the sanctions requested in the plaintiff's letter of December 26, 2024. Those are those adverse inferences, preclusion of evidence and argument, and any other sanctions that the court deems fit, which could include fines. It could include jail. Usually they don't go straight to jail. You know,
this has been going on for a long time, though.
Right.
AG.
This is how it goes. They give him a month. They give him another 6 days. He still doesn't do it. Then they say, all right, you've got another few weeks to tell me why I shouldn't hold you in contempt. And then he files this weird motion. And he's like, all right, case closed, motion denied. The hearing's January 3rd. If I hold you in contempt, now you need to tell me why I shouldn't impose these sanctions that they want. Yeah. And then usually they impose those sanctions, adverse inferences. And that kind of just goes into trial and helps you win the trial if you're Ruby Freeman and Shaye Moss. But the court can also say, I'm also going to fine you, a certain amount of money per day until you produce this. But it doesn't sound like the judge even wants this shit anymore. He's like, fine, keep your cell phone number. I'm holding you in contempt. Yeah. And I'm entering these adverse inferences and preclusions for your trial that starts here in a couple weeks. You're not going to be able to argue that this is your homestead. You're not going to be able to argue that it's in the wrong venue. You're not going to be able to argue that you're too poor. Yeah. And all the jury has to decide is yes or no. He never lived here, and here's all the information that he didn't. So I don't know if there's going to be fines or jail, but don't worry. There's 2 other contempt motions out there.
Yeah. And before we get to that, I will say that when you talk about yes, there's going to be fines or jail. Rudy can't pay. Rudy can't pay these fines. He owes Ruby and Shaye Moss millions of dollars, like Ruby Freeman and Shaye Moss. So maybe the judge might say, hey, you know what? Jail might be the best thing for you. And
you know what? I would agree, frozen.
My friend.
But, I think there's a certain cutoff for what he has to hand over. Anything that he makes after that certain date is still his. So they may be able to say that, we think you're still making money, at least from advertisers. You're hawking coffee on Santa's lap dressed as a woman on Christmas. So you're making something. So we want that. You have to hand over all that to Ruby Freeman and Shaye Moss until you comply. But again, it doesn't sound like the judge is giving him any more time to comply with this discovery order. He said that this is closed, remember?
Yeah.
Your show cause is, at least that is closed. So I don't know if he'll be like, all right, you owe $50,000, $10,000 a day until you actually hand over the answers to number 4 and number 8. Or he might say, nope, don't care about your answers. We're going to assume that that you would have lied, and we're going to tell the jury as much. So we'll see.
We should find out Friday, hopefully.
Yeah, we'll know as soon as Friday. The judge says, be ready.
Yes, be ready.
So we'll see. All right, we still have that 3rd Rudy contempt motion to go over, and there were a couple of late night Christmas Eve filings. Joseph Camerata drinking a hot toddy by the fire, taking his little mittens off to write these motions.
You paint a vivid picture.
Thank you. The fire's crackling, right? The Yule log on the TV is crackling.
Yes, indeed.
So these are going to be the motions of why he shouldn't be held in contempt for failing to turn over his assets in a timely manner. Because you'll remember the judge was like, this is still Judge Liman. He was like, all right, I want you to take pictures of all your stuff. Then I want you to drive it in a car to the storage facility of Ruby Freeman and Shaye Moss's choosing. Ruby Freeman and Shaye Moss, by December 5th, I want you to tell him where you want this stuff delivered. Rudy, you have until Friday. You tell him Monday that you have till Friday to deliver said stuff with all the photos attached to them. And then you have to, he gave very, very specific instructions because he had just been, being handing over the Mercedes, but not the title, shit like that.
Yeah.
And crying about how poor he is. So we have Joseph Camerata's Christmas Eve file. Maybe we should play some Christmas music. Christmas Eve filings as to why he shouldn't be held in contempt, because he certainly did everything he could to comply with the court's order. We'll talk about that after this break. Stick around. We'll be right back.
Welcome back. And now you was talking about playing some Christmas music. We could say Rudy's nuts roasting on an open fire. But no, let's talk about the 3rd motion for contempt, the one where he's failed to hand over his assets. This is also before Judge Liman, who seems to be totally fed up, as we all are, with Rudy's BS. You'll be happy to know that on Christmas Eve, Rudy's lawyer was filing motions in this matter, begging the judge not to hold him in contempt. The first filing argues that the receivers for Freeman and Moss aren't even legitimate because they failed to file oath.
And this is an interesting argument. I don't know that it's true, but it's interesting.
Here we go. Rudy's lawyers write that New York law states a temporary receiver, before entering upon his duties, shall be sworn faithfully and fairly to discharge the trust committed to him. The oath may be administered by any person authorized to take acknowledgments of deeds by the real property law. The oath may be waived upon consent of all parties.
Okay. All right. So I imagine this was actually done and notarized and is probably in a giant pile of discovery that this lawyer hasn't seen yet, but we'll see. The filing goes on to say, it appears that according to the court docket, it appears that the plaintiffs, as the court-appointed receivers, failed to comply with this law, which is CPLR section 6402, and never filed an oath with the court as required by CPLR 6402 before entering their duties to act as receivers. Hence, the receivership has not yet technically or legally begun. The New York civil practice law and rules applies to the judgment being enforced herein. The oath was required to be signed by Plaintiff Ruby Freeman and Plaintiff Shaye Moss as the receivers, and an oath must have been administered by a person authorized to take acknowledgement of deeds by the real property law of the state of New York, and then filed with the court before the plaintiffs undertook the duties as receivers. Even if the plaintiffs could have filed the oath at any time, the plaintiffs failed to do so. It appears that the plaintiffs as receivers have never been permitted under law to act as receivers, as Ruby Freeman and Shaye Moss apparently have not taken oaths, signed oaths, had the oaths notarized or acknowledged, and filed the oaths with the court as required by CPLR 6402. And I'm not sure that's what it says. And I'm not sure the plaintiffs have to take an oath. I think that the receivership just has to sign a thing saying it will, do this fairly and reasonably. Goes on to say, under applicable law, Plaintiff Ruby Freeman and Plaintiff Shaye Moss could not be permitted to act and cannot act as receivers at this time or until oaths are properly executed and filed with the court. Only then, under applicable law, should Ruby Freeman and Shaye Moss be permitted to act as court-appointed receivers. And Harry, as I'm reading this, I'm seeming to remember that it's not Ruby Freeman and Shaye Moss that are the receivers.
Yeah.
There was a third party appointed as the receivership.
Yep.
Obviously, Freeman and Moss are part of that.
Sure.
But I think, and I could be wrong here, but this sounds like something stupid Rudy would do, was saying, yeah, sure. Bob's receiverships, they signed an oath. But Ruby Freeman and Shaye Moss didn't.
Did not, yeah.
And they're required by law. I think they're misinterpreting the law here. I could be wrong, and I actually haven't seen a receivership notarized oath or anything like that. I'll dig through the docket and look for it. But, it could also be under discovery and a protective order that isn't available to the public so that they don't put the names of this receivership out there to be harassed or whatever. Most of this stuff, especially in a defamation case, especially with Rudy Giuliani, you put a protective order on the evidence so that they can't release it to the public. So I don't know. It sounds like bullshit to me, but I obviously we'll see how the judge rules.
Yeah. You say you could be wrong, but I guarantee you that you're right. Until the plaintiffs file oaths pursuant to New York law to act as receivers, the court should not have ordered the defendant to turn over any property to the plaintiffs as receivers. Based on the foregoing and the fact that the defendant complied with the court's orders in full or substantially, right? Like, the defendant should not be held in contempt or sanctioned for any violation, if any of the court's orders, including the turnover order, because the receivers have not been in compliance with New York CPLR 6402, which prevents the plaintiffs as receivers from acting as the receivers in accordance with New York law until the oaths were filed.
Yes.
So that's kind of like saying, hey, the reason why we didn't do it is because, hey, they didn't file the proper paperwork to get the stuff.
That's why you've been not handing shit over until just now.
Get out of here, Rudy.
But also, I know you were like, let me read that again. It's because it's written so
right. Like I knew I read it right, but it's kind of like how you just read his filing last time. It's like, wait, is that really say that? Yes, that's what it really said, you all.
Yeah. And the law says that a temporary receiver, before entering upon his duties, shall be sworn faithfully and fairly to discharge the trust committed to him. The oath may be administered by any person authorized to take acknowledgments of deeds by the real property law. The oath may be waived upon consent of all parties. So it doesn't say that the plaintiffs have to swear an oath as receivers. It just says a receivership. Any person can put it in and say, we'll do this faithfully and fairly. So I think that they're misinterpreting the law here. They go on to say sanctions are not required to coerce the defendant into compliance with any court orders. Oh, really? It is respectfully submitted that the plaintiffs have not established by clear and convincing evidence that the defendant violated the district court's edicts, and therefore, based upon the court's inherent authority, sanctions should not be granted. He's actually arguing that there's no proof that Rudy hasn't complied with this turnover order, even though he said in court that he didn't comply with it. As this court has seen, once the defendant's prior counsel withdrew as counsel on November 26, 2024, present counsel, myself, ensured nearly full compliance with all of the court orders capable of being complied with. Because there has been full or substantial compliance with the court orders by the defendant, sanctions are not required to be imposed to coerce the defendant into compliance. The court orders. That's what he wrote. Additionally, plaintiffs have not suffered. I'm Ron Burgundy. Like, it's just the weirdest thing. Additionally, plaintiffs have not suffered any losses by any non-compliance or delayed compliance. Are you fucking kidding me? You know how expensive it is to keep going after your ass for this stuff?
Exactly.
They have not filed any losses or delayed compliance with the court orders at all. That's also untrue. So there's no reason for this court to compensate plaintiffs for monetary losses, as plaintiffs did not suffer any losses as a result of the lack of compliance by defendant. It's just repeated over and over again. Therefore, based on the facts, there's no reason to sanction the defendant or hold the defendant in contempt. There was no willful noncompliance by the defendant. Wow. As stated above, it is evident that once Rudy Giuliani changed lawyers, a plethora of discovery responses and compliance with the court orders was accomplished. Plethora.
Do these filings have like a word count minimum that they have to have? Because Rudy's repeating so much stuff in these filings and these, oh my gosh, man.
Plaintiffs have not suffered any losses by noncompliance or delayed compliance with the court orders at all. So there's no reason to hold no. And then it says, therefore, based on the fact that there's no reason to sanction the defendant because the plaintiffs did not suffer any losses at all, a result of lack of compliance by the defendant. Like, it's just repeated in different ways over and over again. Just
so
like,
now the judge is going to be like, how many ways can I tell you no?
Yeah. Yeah. It's going to be interesting because Liman had it up to here, as my mom would say.
If the courts were to grant plaintiff's motion, which is respectfully submitted, should not be granted, the only imposition should be reasonable attorney's fees and costs for any monies that plaintiffs expended as a result of any delay in defendants' responses to discovery and nothing else. However, it is respectfully submitted that the plaintiffs have not incurred attorney's fees and costs as a result of any failure to comply with discovery of court orders for the foregoing reasons. Plaintiffs' motions and orders to show cause to hold the defendant in contempt or sanction defendant should be denied in its entirety and for such other and further relief as this court deems just and proper.
Okay, so they're saying that because these lawyers are doing this work pro bono, that there's no costs incurred and therefore no cost should be given. But everybody knows, and again, I'm not a lawyer, but every lawyer should know that it's reasonable attorney's costs, whether you're getting pro bono work or whether you're pro se or not. It's reasonable attorney's fees.
Yeah.
So they're at least admitting to the fact that it costs money. It costs somebody money, right, to go after him for all this stuff. So yeah, he's late and he hasn't complied, but he has fully complied. But he hasn't. But he has. But if he hasn't, it should only be the costs associated with having to have him fully like, it's just this ridiculous circular thing, which is why I really question this oath thing for the receivership. Like, I'm interested to see what Judge Liman says about this. I have a feeling it'll be something along the lines of the receivership is a third party and submitted good faith documentation notarized on such and such date. Ruby Freeman and Shaye Moss aren't required to take oaths and submit that on the docket.
And then watch Rudy file an appeal to that ruling. Like, it's...
he could file a motion to consider all day. The judge will be like, nah, bro, no. Also, this is fun. Rudy filed a declaration about... Okay, so remember we talked about Judge Liman's very specific instructions on how to comply with the turnover order. Like, I'm tired of your bullshit. You handed over a car without a title. You moved all your stuff out of your apartment. You hid it in a storage facility. Didn't tell the plaintiffs where it was for weeks and weeks. So now here's what you got to do. You got to go to that storage facility. You got to take pictures of every single thing that is in my turnover order. And then you got to drive it to this thing and you got to do this. Well, Rudy filed that he has complied. He filed a sworn affidavit to the court that he's complied with this stuff. I'm the defendant. I submit this declaration. I respectfully submit this court should deny Ruby Freeman and Shaye Moss in their motion for an order to hold me in civil contempt. The October 22nd court order, that was the list of all the shit he had to hand over, subject to turnover and receivership. He says the shares of my interest in the apartment in New York, 45 East 66th Street. I signed documents that were requested by the plaintiffs for this property, which was signed in the courthouse November 26th, 2024, November 26th, and given by my counsel to the plaintiff's counsel. I complied with this. Yeah, after we've fucking hounded you.
I was just about to say, like, it wasn't easily turned over and complied with.
All the rights and interests and cause of action for fees owed to Mr. Giuliani for services rendered for being Trump's lawyer. Plaintiffs have not requested anything regarding this. Well, they did. They requested that they take over the bill, and that happened. The non-exempt cash in the checking accounts held at Citibank. I signed documents directing Citibank to turn over all non-exempt cash in the checking accounts held by Citibank to plaintiff, and he attaches an exhibit. He doesn't say when he did that, but he said I did, probably just yesterday. Mercedes-Benz model. I turned over the physical Mercedes-Benz and complied with this request, and plaintiffs acknowledged that they received the physical Mercedes-Benz. I had the vehicle delivered to Miami, Florida, as requested by the plaintiffs. He doesn't mention the fact that he didn't get the title. Various items of furniture. I turned over 42 items, which is more than the court ordered specifically required. Book cabinets, 3 living. He turned over shitty furniture, not the really expensive stuff that they requested. Like a IKEA storage bed drawer, 1 storage bed drawer, living room coffee table, folding chairs, but they're upholstered, so that makes them very nice.
Upholstered folding chairs.
A rolled mattress. He gave him a mattress cot. They're like, we didn't want your fucking mattress cot, man. We want.
Oh my God, man.
A cushioned ottoman. Some lampshades, not the lamps, just the shades.
Just the shades of them.
He wears those as hats at parties. Pillows.
Wait, can you imagine getting a Rudy Giuliani mattress? Like, ew.
Pillows. He turned over pillows. And he's like, that should take care of my obligations.
That's worse than the mattress.
Master bedroom slats. I don't know. What is that? Like a...
I think those are those things that go in your bed frame.
Yeah, the bed frame. Master bed side rails. Sofa bed legs. Not the sofa bed.
Just the legs for the sofa bed.
Nightstand. A footboard. A master bed mirror. A storage. Okay, so he's taken apart his bed frame into 13 pieces and says he's handed over 13
things. No, you gave a bed set.
Headboard. Dresser. Plus, there was a significant amount of furniture contained in the New York cooperative apartment, which was turned over to the plaintiffs. The court should note that I turned over what I was required to turn over and more, like the slats and the side rails and the headboard and the drawer underneath and the sofa legs.
Unbelievable.
Wow.
Unbelievable.
Television. I turned over a television. Okay, thanks. We don't want your fucking television. Sports memorabilia. I turned over sports memorabilia, including Yankee pictures, Yankee banners, Mickey Mantle picture, John Daly framed art, Derek Jeter photos. See all of my exhibits. So remember why we were supposed to take photos of everything? He took photos of some of his Yankee banners, Mickey Mantle, John. He's got 5 photos in here.
Still writing on those rings, Rudy, that you gifted to your son.
There's no Reggie Jackson picture. The picture was Derek Jeter. So, okay. So correcting the court there. He actually has I think a Reggie Jackson picture. He just doesn't want to give it up. The Yankee Stadium picture is a hallway Yankee picture. There's no signed Joe DiMaggio shirt that I possess. I believe that the signed Joe DiMaggio shirt was hanging in the New York co-op apartment at the time the apartment was turned over to the plaintiffs. He says he can't find the Joe DiMaggio jersey. So he hasn't fully complied. Okay. The court order did not specifically state I had to turn over the Yankee banner or the Mickey Mantle picture or the John Daly art. We don't want this shit, bro. But I turned these over anyway. I've given all the items to the court. Costume jewelry and a diamond ring. I do not possess any costume jewelry. I turned over my diamond ring. I turned over 18 watches. I turned over all the watches I possess. I respectfully
this reads like Dr. Seuss.
I respectfully submit that the items which I was required to turn over, I've turned over. The court should see I gave everything that I could give. I gave items of furniture and sports memorabilia that were not even listed in the court's turnover order. But I gave them anyway to ensure that I was complying with this court's order. Okay. So it goes on.
Thanks for your hard work, Rudy.
I provided a detailed list containing pictures of the segregated receivership property located at my facility. See docket number 200 as required by that order. I provided the location of the New York-based storage facility to the plaintiffs. He doesn't say when he did that. I complied with the court's 3 orders to turn over order, the instructions order, and the modified instructions order. I've not intentionally or willfully disobeyed any of the court's orders. Oh, you so are full of it. So I respectfully submit I should not be held in contempt or sanctioned. Wherefore, it is respectfully requested that the plaintiff's motions for contempt and sanctions be denied in its entirety. It should be in their entirety. And for such other and further relief as the court deems just and proper, I declare this under penalty of perjury, that the foregoing is true and correct. Maybe I can get him on perjury, because this is full of shit.
Yeah. Yeah.
So he had to turn that in on Christmas Eve too. So lovely Christmas story. Not my favorite.
Not the best
Christmas story, but so January 10th, Judge Howell contempt hearing for continuing to defame. January 3rd, contempt hearing for probably the turnover stuff, but definitely the failure to provide discovery. And I think we could see some adverse inferences and preclusion sanctions by the next time you and I talk.
I was just about to say, we'll probably have some really good updates in the next couple of days. So that'll be interesting.
Yeah. Oh, and his thing is due to Judge Howell tomorrow. So that's also fun. This was a Rudy Contempt-apalooza episode. There was just so much to share and discuss. So thanks everybody for hanging in there with us. We know it was a lot. It was a lot of filings. It was a lot of filings that were hard to read because they were penned by Joe Camerata. But we got through it. Now you know, you're all caught up on all the Rudy stuff. I'm going to dig in a little more about why having a primary residence or a homestead means it doesn't have to be handed over in receivership. And I'll also see if I can find out about this oath thing.
The oath thing.
But
you know what? Rudy could have avoided all of this if he just didn't lie and defame people. What have we learned today, ladies and gentlemen? Don't lie and defame people. You won't end up like Rudy Giuliani.
Yeah. And these are the corners of our justice system that work. Again, they're slow, but it's nice, when you see the Second Circuit upholding the E. Jean Carroll verdict, or when you see all of these different contempt hearings and motions coming to a head for somebody like Rudy Giuliani. And, like the judge said, you have to comply with the court's orders or there's going to be consequences. They take a long time and it's step by step and it's little by little, but you can't run forever.
Yeah. And like I teased earlier in the beginning, a lot of people, or myself included, were very disappointed about Donald Trump and the immunity and the Jack Smith dismissing the charges. But there's still civil penalties that Donald Trump is going to have to answer to, and those won't be whisked away. Some of those by some members of Congress, some Capitol Police officers. He will have to answer for that. So it's slow, but stay tuned. It is still coming.
Unless the Supreme Court makes a new rule for the ages and decides that sitting presidents can't be party to any civil cases. Going
against what they've already established that they can. Yep. But we'll see. Mm-hmm. But with this Supreme Court, who knows?
Yeah, they like to go against stuff that's already precedent. They kind of ignore stare decisis altogether. Thank you all so much. Thanks to our new patrons. We will be back in your ears next week. If you're a patron, we'll have a bonus episode for you this weekend. And everybody have a really safe and happy new year.
Happy New Year.
Yeah, happy New Year.
Happy New Year, y'all. Hey, Allison, happy New Year to you, my friend. I can't wait to see what this year brings us. And I am so looking forward to having a full year with you and all of our wonderful listeners. Thank y'all for making my first month easy, effortless, painless. I love getting on this space with you all. And thanks for having me aboard, my friend.
Anytime. It was an easy decision because you are so well loved by, including myself. Thank you, my friend.
I love that. Love that.
We'll
Thanks,
see everybody
y'all.
this weekend. Until then, I'm Allison Gill. You know me.
Harry Dunn. Thanks, everybody.
Cleanup on Aisle 45 is written, researched, and produced by Allison Gill with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.